Hello and welcome to the Coordinating Center's second installment of our Community Enrichment series. Today's topic is going to be on advanced directives, guardianship, and power of attorney. Today's presentation, next slide, will be recorded, so please remain on mute. Feel free to use the chat feature to ask questions. We'll do our best after the recorded portion to discuss your questions during our Q&A portion. So during our Q&A, please trust that this is a safe space with no judgments, and we will email you the slides and any unanswered questions as best we can following today's presentation. Because of the legal nature of our topic today, we want to emphasize that this webinar is intended for informational purposes only and is not a substitute for professional legal advice. I would encourage you to consult with your own legal guidance professionals, medical professionals, family members, loved ones, faith leaders, whatever is important to you as you're making these decisions. Objectives for today include for us to be able to describe the various types of documents that are available pertaining to healthcare decisions, differentiate between these types of documents, and to understand when to seek clarification regarding these decision-making documents. So my name is Nikki Dozier. I'm the social work consultant for the Coordinating Center's Community First program. I provide clinical guidance to supports planners, and they're the ones that are coordinating home and community-based services for individuals across the entire state of Maryland, including older adults and individuals with disabilities. We assist them to live and remain in the community of their choice, which also includes folks who are in nursing homes who want to move back to the community. We do our best to help aid in that. So I've been a social worker licensed since 2007, and I've spent most of my time in the medical field. I worked at a big old hospital in Baltimore for a couple years. Then I did home hospice care, which also covered the inpatient unit on call. And then I worked a number of years at a CCRC, a continuing care retirement community, primarily in the nursing homes, so short-term rehab folks and long-term care residents. We also covered assisted living there, and I worked with independent living residents as well. And then for almost 6 years, I've been with the Coordinating Center with our home and community-based services. And again, I'm not a legal expert. Don't try to be one. And I'm certainly not trying to provide legal guidance today, just trying to help us all understand a bit more about these different types of documents and the differences between them and when one might make more sense than another. So today's topic, why does it matter? We want our own wishes to be known. We want our loved ones' wishes to be known. And simply put, we want these wishes to be followed. So I'm going to just go through a couple scenarios here at the beginning and then think about them as we go through, and then we'll wrap up at the end, just kind of summarizing briefly what would make sense in these scenarios. So first, imagine a scenario where a widowed mother of 4 adult children has an unexpected medical emergency and tough decisions are needed about life-sustaining measures, medical treatment. What about a minor who is non-communicative and about to turn 18 and become a legal adult? Like other 18-year-olds, will this 18-year-old be expected to manage their finances? Will they be able to make their own day-to-day decisions about where they live, their medical treatments? What if you have an adult child and they become unconscious, they stop breathing, they go to the hospital? Is the hospital staff, the ER staff, are they going to be able to communicate confidential health information to you? What if decisions have to be made? Who's going to make those decisions? Then let's say we have an 85-year-old family member whose illness causes a decline in their cognition. If they're really confused, who makes decisions for them regarding their medical care? Or a cancer patient who's terminally ill and they become unable to make their own decisions. Who would the medical providers turn to? So let's learn about some of these different documents so that we know better how to be proactive in scenarios like this in the chance that they ever come up in our lives. So in considering these type of scenarios, in my opinion, at least, there's a lot of confusing language around this topic. Like, what's the difference between a guardian and a POA? Is there a difference between a POA and a healthcare agent? What the heck is most? So we're going to go through all these today. So first, let's talk about advanced directives. An advanced directive is a written document to guide healthcare providers when an individual is unable to communicate for themselves. The document is completed by someone when they are cognitively able to do so. So I'm going to hit home on that point a couple times today. So it's a written document that's completed while someone's cognitively able to do so. So advanced directives typically contain two main portions. So the first main portion is where the person would name a healthcare decision maker. So this is where the person, while they're cognitively able, they're able to name who they would trust to make healthcare decisions for them on their behalf, if and when they're no longer able to themselves. So we're talking about confusing language already here. So healthcare decision maker, that's what it was called in my prior job, HCDM, I'd see all over the place. But it's also sometimes referred to as a healthcare power of attorney, healthcare POA, healthcare agent. Sometimes you see the term healthcare proxy. So the lingo is already confusing, but it all means the same thing. It's while someone's cognitively able, they are putting in writing who they trust to make medical decisions for them. One or more people can be named in order or together. So I didn't know I'd see the questions pop up. Sorry if I get distracted by them. So in these documents, typically the space allows where you can name one decision maker. If they're unwilling or unable, they could name a backup. If the backup is unwilling or unable, you could name multiple people. There's also the opportunity where, let's say someone has 2 adult children. They might want to put their 2 children as their primary decision makers. And then if they're unwilling or unable, then maybe they list a backup or a backup or a backup. My experience, so again, this isn't legal guidance or anything, but in my experience working on the healthcare side of things is that it can be a bit more challenging if there's more than one person named with equal authority. Because what if they're not in agreement? Ideally, they would be, but what if they're not in agreement? It can be a little tricky, and we'll talk a bit more about that later. What could help them be in agreement is the second main portion of an advanced directive is what's called a living will. So not to be confused by a last will and testament. Like if you ask someone if they have something like a living will, they say, oh yeah, like my daughter's going to get my house. This and this is all laid out, spelled out for everyone. A last will and testament is, what happens with your estate, your belongings after one passes away. A living will is about while you're still living. So a living will portion of an advanced directive is where the individual spells out their medical wishes, and it's supposed to be used as a guide for healthcare providers and decision makers. So people can spell out if they would want treatments like IV fluids or feeding tubes, or if they'd want to be, on a ventilator, things like that. So it's spelling out what type of medical treatment they would or would not want. And the way it's spelled out in most of these documents is if they're in a vegetative state, a terminal condition, or an end stage condition. Next slide. So advanced directives also typically specify when the document becomes effective. Now, usually it's one of these 2 options here, in similar words at least. So document becomes effective immediately upon signatures, or the advanced directive becomes effective once 2 physicians have certified the person lacks decision-making capacity. So it seems like a pretty clear difference, but we have this slide here. It's come up a few times in the CFP, Community First Programs world, where folks who are named as decision makers try to take that and run with it. So making a document effective immediately does not give the agent authority to override the individual's wishes. As long as that person is still able to make decisions for themselves, they're the ones that should be making the decisions. The person named as a decision maker is for when the person is not able to make their own decisions or unable to communicate them. The difference between when the document becomes effective is, like, if something were to happen today, if there was a medical emergency today, either that person could immediately become the decision maker, speak on their behalf, or two physicians would have to do depending on how urgent of a situation is, a quick capacity assessment to determine if the person's able to make decisions. So regardless of how it's spelled out, the document becomes effective one of those two ways, but as long as the person is able to speak for themselves, they should be the one speaking for themselves. We had a mother in Montgomery County of an adult client who was very capable of, he coordinated his own transportation to and from appointments. He managed his own medications, but he had an advance directive naming his mother effective immediately. And she took that and tried to run with it and was really trying to run the show and wasn't letting him speak for himself. So it took a bit of conversations for us to do our best to make that as clear as possible and to advocate for the client. Next slide. So just other important things to note for advance directives. In Maryland, they require to be signed by the person and with two witnesses. It does not need to be notarized in Maryland. Financial powers of attorney do need to be notarized, but medical POAs, advance directives do not need to be notarized, just two witnesses. And the document oftentimes tells you who can and can't witness. It shouldn't be anyone that's listed as a decision maker. And I think the way it's worded is at least one of the two witnesses can't knowingly inherit anything upon the person's passing. It's up to the individual and the decision maker to make sure that they have updated copies of the advance directives to give to the medical providers, maybe have one handy. If someone were to go to the ER or go to a new doctor's office, new specialty provider, things like that. Advance directives do not expire. Any new versions or updated advance directives just automatically trump the prior versions. In prior jobs where we looked really closely at these things and I was required to ask and educate folks on these things, I found that it's important to know that both of those main sections of an advance directive don't necessarily have to be completed. Someone could just do the living will portion, or someone could just do the healthcare agent naming portion. I mean, a lot of us don't want to think about our end of life terminal illness type of medical wishes. Although I think it's very important to. I understand that a lot of us might not know or might not want to think about it. But a lot of us, on the other hand, might very easily be able to identify and put in writing who we would trust to make decisions for us if something were to happen where we couldn't. So I think it's good to know that not both portions have to be completed. And then a very important point, only the individual, let me see if I can change the setting on that. Okay. Only the individual can change an advance directive. So again, it's choices put in writing, wishes put in writing by the person when they're cognitively able. So only they're the ones that can change it. We had a resident in the nursing home who had an advance directive naming her daughter and then her son as the backup. Daughter was always around, always available, knew everything going on with her mom and her medications and her her medical care. She approached us one day and said, you know what? My brother's not, he's not as involved. To be honest, I don't think they really got along. But she said, you know, he doesn't know everything going on with mom. I think my daughter should be the backup instead. I understood where she was coming from and why she approached that with us, but her mother would have to be the one to make that change. And at that point, her mother wasn't cognitively able to anymore. And it was a non-issue. The daughter was always around and always willing and able. So just keep in mind that only the individual can change an advance directive. So the next slide just shows a couple of examples of versions of advanced directives. The one on the left is called the 5 Wishes. It's recognized in a lot of states across the US. The one on the right is through the Attorney General's website. So I'm very familiar with this one. It's the Maryland Advanced Directive, and you can print it out online for free. The 5 Wishes you either have to find maybe at a local senior center, or Department of Aging might have some copies. But if you were trying to get one on your own, there's a little fee for it. But just showing these 2 examples reminds me to tell you that they can look very different from each other. So some folks might go through a lawyer to get a financial POA completed, maybe working on their last will and testament. So while they're with them, they'll say, hey, let's do an advance directive too. So one lawyer's office to another, the documents look a little different, read a little different. They could be typed up. They could be typed up as long as they're signed and witnessed. I wouldn't recommend it, but I've even seen a handwritten one that was signed and witnessed, and it was very brief. It was just naming who they wanted to be the decision maker, and that was it. But with the two witnesses, that counts in Maryland. So the next slide, there's some links to some resources for you, and again, you'll get these after our presentation today. So just overview, more information about advanced directives. The second link is the actual advanced directive, the Maryland one itself. A lot of this stems from the Maryland Healthcare's Decision Act, which I'll reference a couple times today. And there's also a link for the 5 Wishes document there. So next, let's talk about a MOLST form. It's the Maryland Medical Orders for Life-Sustaining Treatment. So that's a mouthful, so they've shortened it down to MOLST. In other states, you've maybe seen POST, like physician order for life-sustaining treatment, or somewhere I saw POST, physician orders for something or other treatments. But in Maryland, it's the Maryland Medical Orders for Life-Sustaining Treatment. The way I understand the document, the main purpose of it is where it talks about code status, if someone would want to be resuscitated or not. So yes, they want CPR, or they want a DNR order, a do not resuscitate order. The document also talks about other life-sustaining treatment options. The MOLST form is completed and signed by a healthcare provider. So it has to be signed by a doctor, a nurse practitioner, or a physician assistant. And it's completed and signed by the medical provider based on a discussion they're having with the individual and or their decision maker. So that's a big difference if you're ever trying to figure out what kind of documents maybe someone already has in place or not. If it's something, if they say, oh yeah, the doctor did something with me last time I was in the hospital, chances are they might be talking about a MOLST form if the doctor helped fill it out or signed it. Versus an advance directive, that's done by the person, like they did it themselves and they signed it. The way it's written out in Maryland is that most forms should, at the very least, be completed when someone goes from an acute care hospital to a nursing home, so that the nursing home staff knows what their code status is. Someone goes from hospital and start receiving home health care. Certainly if someone's going to dialysis, they're at a dialysis center for so many hours a week. So the most form should go to the dialysis center. Same with assisted living facilities, someone under hospice care, and if someone were to go from one hospital to another. So very important thing to know about the most form. This is the only form that emergency crews, the ER staff, other healthcare professionals can rely on to know if someone does not want to be resuscitated. Some people might spell it out very clearly in their advanced directive living will portion that they don't want to be resuscitated. But as we saw before and discussed, advanced directives look very different from one another. There's that Maryland form, there's the 5 wishes, there's lawyers' documents. They all look very different from one another. So the expectation for an emergency crew where split-second decisions have to be made, to be able to go through a big document and flip through pages to try to find something about code status and will they read it in a way that's accurate, or there's just more room for error. So although a living will is important, it is not what's going to matter in that immediate scenario. So EMS crews, ER staff, if someone doesn't want to be resuscitated, they have to see an order for that. And the order is the most form, the medical orders for life-sustaining treatment. Some people say, well, if I don't want to be resuscitated, then I feel like I need to have this form with me everywhere I go. Yes, if there's a way you can, yes, please. But some people might say, well, isn't there a bracelet I could wear for that? I think we could all go online and find all sorts of bracelets that might say something or other. But in Maryland, with the most form, there's one specific company that can issue bracelets through Medical Alerts, where part of receiving the bracelet is by giving them a copy of your most form. So that's the only other thing that emergency crews can recognize to know that someone doesn't want to be resuscitated. With that said, also, the person will know, the individual would know if they have a medical order saying they do not want to be resuscitated. But I would encourage everyone in their life to know that, anyone going in and out of their home. So for instance, if they're in one of our programs or REM or CO waiver, DDA, if somebody doesn't want to be resuscitated, everyone in and out of that home should know that and know where the most form is. So when I did home hospice care, oftentimes the guidance would be to stick it on the wall behind the head of their bed if it was someone that was typically in bed. Other people would say, put it on the back of your front door. I don't like that idea personally, because if emergency crews rush in, they might not see that most form on the back of the front door until they've already attempted resuscitation and they're on their way out with the person. So that too is why I think it's just very important for anyone in the home to know where the form is and to know that it exists. So the next slide shows what a most form looks like. It's usually front and back kind of document. I know there's a lot on your screen here and it might be a little hard to see, but the first page is, the front page is, who the medical provider reviewed this with. And the bottom part of that front page is the actual code status. If they would want CPR, or if they don't want CPR, would they be okay to be intubated or not? Or do they just want supportive measures? So that first page is very important. The back page also important. A lot of times it's not completed. You might see the medical provider put a line through it and sign it like they didn't review this or they're going to do it later. But if you ever do see the backside or the second page of a most form completed, this is where it talks about other life-sustaining treatment measures. So it talks about artificial ventilation. It talks about things like IV fluids or feeding tubes. So this is a little confusing. It was to me, at least. It took me a long time to wrap my head around it. The medical wishes here say, well, what's the difference between this and an advanced directive living will medical wish? This is what took me a long time to understand. Most form, because it's a medical order, it's an order, it's a current active order. So these medical wishes would be, if something happened today, these are the medical orders that would be followed. An advanced directive living will medical wishes, those are for future in a terminal end stage condition. So ideally, you would see the wishes align in both documents, but they don't have to. Like me as I'm a now 40-year-old person, my wishes as a 40-year-old, my wishes for now might be different than if and when I'm ever in one of those other conditions, a terminal or end stage condition. So ideally they align, but they don't have to. I think I touched on everything I wanted to about a MOLST form. The next slide are some links to resources for you, the actual MOLST form itself, and then an FAQ sheet that includes information on the medical alert, the bracelets. Next slide, Heidi. And then again, the Maryland Healthcare Decision Act, which I referenced. Another info page about the MOLST. There's a whole lot of MOLST information, and you'll see if you start looking on some of these sites and the prior list of resources, a lot of them will talk about all these documents within their websites as well, just so that everyone's aware of, well, MOLST form does this, it's different than an advanced directive in this way. So feel free to take a look at all of these because they're super informative. So next, let's talk about guardianship. So guardianship for adults, the big takeaway for me is that it is court appointed. So guardianship is court appointed when an individual is unable to manage their needs due to their cognitive or functional status. So if someone is incapable, they could, through the court, be appointed a guardian of person, which manages their personal matters, and they could be appointed a guardian of property, which is concerning their financial matters. So oftentimes the guardian of person and property is the same person appointed. But other times we might see a different guardian of person than the guardian of property. Guardianship is, I don't know if job is the right word, but guardianship is a responsibility. You have duties. You have to report to the courts each year. You need to be, it's almost like you're renewed, like you're reapproved each year to continue being the guardian. Some people, you know, that's a big responsibility. We don't all have that in us. As much as we care about someone, we might not be able, we might know that that might be too much for us. So sometimes someone might be willing to be guardian of person because they're helping manage a lot of that stuff already anyways. And maybe someone else, like a CPA's office or a lawyer's office, might be appointed the guardian of property. If there's no one in the person's life or no one's willing or able to step up and be that role, depending on the person's age, the guardian of person would be appointed either through the Department of Social Services if they're under 65, or guardian of person would be appointed to the local area agency on aging for folks over 65. As part of the court proceedings, the individual considered disabled is appointed an attorney through the court if they don't already have one themselves. And I think this is a really important part of the process so that the person has an advocate. You know, someone might say, oh, I think so-and-so, I think my loved one needs a guardian. That person is going to have the opportunity to tell their side of the story, to prove themselves if they don't feel that they need a guardian. And they can also shed light on who they trust. If someone has done them wrong in the past, it gives them the opportunity for someone to advocate for them. For folks under age 18, so minors, parents are legal guardians by default without being court appointed. So in at the coordinating center, sometimes in our Community First programs, sometimes there's a little confusion. Someone might become a client of ours when they're age 16. And so when we enter their parents' information in the system, the parents are the guardians. But what we have to remember and be very mindful of is, okay, as that person is approaching age 18, when they become age 18, the parents are no longer the guardians. It can be confusing even for the parents, right? Like you've managed the lives of your children, and it might be someone as an adult still need a lot of assistance. And we're used to signing, the parent or guardian line. But unless you are court appointed as a guardian, once your child turns 18, you are not the guardian. It really is the last resort because it strips away the rights of the person. So there's a lot of alternatives to guardianship. For instance, if someone is cognitively able to do an advance directive, put a healthcare power of attorney in place, a financial power of attorney in place, there's a rep payee, perhaps, coming down the pike in some states and soon maybe in Maryland, something referred to as supported decision-making. There are also mental health advance directives. So there's a lot of opportunities for things to be managed for someone that needs that help without going to court. So just keep that in mind. Sometimes it really is the best answer and makes sense, but a lot of times there might be other alternatives before guardianship is appointed. So the next slide is the best thing I could find to look like a guardianship document, and really it's to hit home that it's a court document, it's a court order. Luckily, you can't just go online and find blank documents. So this is the best version I could find, just to hit home again that it's a court order, it's a court proceeding. So the next slide includes links to resources about guardianship. The first has a lot of good information describing the roles and duties of guardians. Again, it's not just a one-time hearing and you're done. You have to do the paperwork, show that you're doing right by the person. It also includes forms including that initial petition for guardianship. And that initial petition for guardianship spells out that you need 2 incapacity certifications completed by physicians to submit with that petition. And if there's any other document already in place, sometimes in advance directives, we see if guardianship is ever needed, I want who I've named as my healthcare decision maker to be the appointed guardian, if at all possible. The second link is it's a pretty lengthy handbook, but it's a handbook on guardianship and its alternatives. There's another link there, just more about guardianship. And then the adult public guardianship, that last link is pertaining to folks that don't have any family or loved ones or friends willing or able to step up and be in that role. So there's a public guardianship proceeding for that. Next, let's talk about what's called surrogate decision making. So what if there's nothing in place and doctor has deemed someone as incapable of making medical decisions? For today's training purposes, let's assume there's not already a court-appointed guardian in place. Technically, guardians are a form of a surrogate because the individual didn't name them themselves. So if it's anyone else determining who the decision maker is, it's considered a surrogate decision maker. So technically, court-appointed guardians are surrogate decision makers. But let's assume for today's purposes that there's no guardian. decisions by default would fall to a spouse. If there's no spouse or widowed or never married, decisions would fall to adult children. Children, not adult child or oldest child. All children, equal authority. If there's no children or they're unwilling or unable, it falls to parents, plural. If there's no parents or the parents aren't willing or able, it falls to adult siblings, plural. And if there's no siblings, then it would go on to other relative or friend. So let's just play out a couple scenarios here. So let's say let's say you or loved one or someone you're working with has never been married, but they have 5 adult children, and they're no longer able to make decisions for themselves. Let's say of the 5 kids, one of them lives with you, knows everything going on about your care, your medicines, your doctor's appointments. Let's say another 2 live close by, they're involved, help with groceries, errands, a little respite for the one that lives with you. Let's say another one lives in California. Certainly doesn't mean they can't be a decision maker, especially this day and age with technology and everything. And let's say the 5th one, maybe they're estranged and they haven't talked to you in years. A lot of people would think, oh, well, that one that lives with mom and knows everything going on, wouldn't that be the surrogate? They'd all have equal authority, technically. So that can get tricky. Imagine if there's a medical emergency, emotions are running hot, tensions are high. To expect all 5 children to be in agreement with things, that's a lot to ask, I think. It could be that they all are in agreement, but reality is a lot of times that would not be the case. So then what happens? Does it postpone timely medical treatment until they all get on the same page? If one thinks everything under the sun should be done, but another person thinks no, like I think mom would rather just let things go naturally, it can be challenging. In that case, if the person had done a living will part of their advance directive, that would help guide the children. But if they didn't specify who they trust to make those decisions and enforce those choices, that'd be hard. And so parents, if there's, 2 parents, for them to be on the same page could be challenging. Siblings, certainly. Or what about the scenario, which we see quite a bit? What if you have an adult child, but your closest confidant and who you would trust with this kind of thing is your cousin you grew up with, like a sister? Where's cousin on this list? The adult child would be before that. If there were any other siblings, would be before cousin. So just playing out some of those scenarios, I think, can be helpful to really hit home the importance of putting in writing, while someone is cognitively able to do so, who they trust to make decisions. And spouse, I forgot to mention the spouse piece of it. Unless they are divorced, a spouse who maybe has been separated from the person for years, if they know that they have this surrogate priority here, they could come out of nowhere and change the course of treatment for someone, technically. Now, certainly, depending on the medical setting, there's ethics committee meetings and things to really sort through this kind of thing. But an ex could step in and be that surrogate decision maker. I worked with a lady in this role who, when I first met her, I saw her marital status was separated. I learned that she didn't have advanced directives, nothing naming a decision maker. When I brought it to her attention, she told me that her and her ex, they share an adult child together. He lives in the neighborhood. They talk on the phone weekly. They see each other pretty often. They're friends, but certainly not a partnership anymore. She said she wouldn't trust him with a 10-foot pole. Said, well, then you might want to consider putting in writing who you would trust to make medical decisions for you. So those are just a couple scenarios of why it's so important to put in writing. There's no the Maryland Healthcare Decisions Act doesn't identify like a document for this type of surrogate decision making. It kind of is, the way I see it is almost like the medical setting. They'd have to do their due diligence to figure out if there is a spouse, how many children there are, things like that, to determine who the surrogate is. I have seen a document where, let's say there are those 5 kids and they all agree that the one that lives with mom and knows everything going on closest, that she should be their spokesperson. They could all put that in writing, but that could change any time. As soon as one of them says, nope, I don't like how she's making decisions, they could take that back and say, I want equal authority as her. Okay, so the next slide is more information about surrogate decision making, spelled out in that Healthcare Decisions Act, and it's also discussed in the in that Alternatives to Guardianship handbook that I referenced earlier. So I'm looking at the time, as the next slide says, like, whew, that's a lot of information. And so as we went through some of these slides, you might be thinking about yourself and what your wishes would be, or who you'd want to help put those wishes in place. You might think about loved ones, your family, your parents, your adult children, or your minors who are maybe approaching 18. Some of us might be thinking about our different client scenarios. So I recognize that it's a lot, and hopefully these slides and the links that we send you will help clarify anything beyond our session today. But I just want to take a pause and recognize that it's a lot of information. So the next slide was my attempt at like summarizing the documents and who's in control of them and who can change them and things like that. So advanced directives are done by the individual while they have cognitive abilities. They're the ones that sign it with 2 witnesses, and they're the ones that can change it. Same with the most form, unless they lack capacity and they've named a healthcare decision maker. So it's the individual and or the decision maker that decides, that reviews the most form, but it's signed by the healthcare provider, and them together would be who changes it. Guardianship is all determined by the court. It's a court order. Any changes regarding to guardianship needs to go through the court. And then surrogacy works a little different. It's kind of determined by the way the law is written in Maryland. There's no form to be signed necessarily, but anyone in those surrogacy priorities could say that they're not willing or unable, and then they'd move on to the next line. So quick recap, just going back to those scenarios from earlier. Scenario where widowed mother of 4 adult children has an unexpected medical emergency and decisions need to be made. Without anything in writing, it would fall to her 4 children equally. If she put something in writing prior to her not being able to speak for herself, that would help the medical providers know who to rely on. A minor who's non-communicative and about to turn 18, depending on what their abilities and capabilities are, perhaps they don't need a guardian. But if they are unable to communicate, if they're unable to manage their finances, their healthcare decisions, guardianship maybe would be necessary. If your adult child becomes unconscious or stops breathing and they go to the hospital, can the hospital share information with you? It depends. Do they have a named decision maker in writing? If they don't, do they have a spouse? What if your adult child is 25 and they have a wife? Their wife would be the surrogate that the hospital should be communicating with before you as their parent. And then same with the 85-year-old who gets more and more confused, can't make their own decisions, or a cancer patient who becomes unable to make decisions. Again, that would all depend on if they've already named a decision maker. If not, surrogacy would come into play. So it would depend on their marital status, if they have adult children, how many, things like that. So this slide here, just for overall additional guidance, like if you're really thinking, ooh, I think I might need to pursue guardianship for my loved one. There is a legal clinic calendar where you can search by topic and county, legal services directory where you can search by keyword, county, and category. Maryland Legal Aid is an awesome resource, Disability Rights Maryland. And also, I told you that the handbook on guardianship and its alternatives is pretty lengthy. So towards the end, pages 63 to 73, there are additional statewide and county-specific options. And again, as I said earlier, as you're going through any and all of this, if you have your own lawyer, your faith leaders, your family members, loved ones, really, really, you want to have informed medical decisions for yourself if you're putting them in writing. If you're trying to advocate for a loved one that might not be able to do so, just seek all the info you can as you're going through this process. So that about wraps up my presentation. Before we move on to our Q&A, wanted to share with you all that the third installment of our community enrichment series will actually be presented by my supervisor, Megan Bazette, on Tuesday, March 19th, Finding a Voice Through Self-Advocacy. And then following that, we'll have Transitioning to Adulthood presented by Alyssa Stoffel and Cheryl Nickel. And then we're going to have Kelly Nelson with the Maryland ABLE program teach us about ABLE accounts. So now we'll stop our recording and move on to our Q&A. I'm going to open up the chat.